When it comes to their writing, lawyers have a certain reputation, and it's not really a good one. Lawyers often put, and you know this, too many facts, details, arguments into the things they write. Lawyers' tendency to overinclude. Why is that? I think a couple of reasons, and again, please offer up your own if I've left some out or you have some others you want to share. I think we often try or think we need to use it all to justify our research. Good writing is not always about adding stuff. Adding stuff can often make your writing less good. It gets in the way of the good stuff. It can keep your writing from being clear because more is not always better. It can make your writing less accessible.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Rick Horowitz. Rick Horowitz is the founder and wordsmith-in-chief of Prime Rose LLC, offering legal writing workshops to institutions and organizations across the country. A graduate of Brandeis University and NYU School of Law, Horowitz worked at a Washington law firm specializing in communications law and as a legislative assistant to a member of the congressional leadership. He also went on to become a nationally syndicated columnist, winning 2 national headliner awards, and he was a commentator from Milwaukee Public Television, where he received 8 regional Emmy Award nominations and 2 actual statuettes. The webinar presentation that you're about to watch will be approximately an hour and a half, and if you have any questions for Rick during the webinar, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen and submitting those at any time. And we will also have a designated Q&A portion once the full presentation is complete, so you may also send in your questions then as well. Now, without further ado, here is Rick to discuss what stays, what goes, crisper, clearer, tighter legal writing.
Hello, everybody. Thank you, Nina. Thanks to Nina. Thanks to Arturo, who's handling the tech side of what we do today. My name, as Nina said, is Rick Horowitz. I am the founder and wordsmith-in-chief of Prime Prose LLC. I do writing workshops for various organizations, bar associations, nonprofits, different organizations, government agencies, all those things. I am not an AI creation, although we can talk about AI as well. Let me thank you for being here. Let me tell you that in addition to those jobs that Nina has mentioned, in doing the legal workshops, legal writing workshops, I have found myself increasingly serving as a stress reduction counselor as well. And that makes a certain amount of sense. Lawyering is difficult, you know that, and writing is difficult. When you combine those two, you can understand how that might be even more stressful for you. So my hope today is that we'll do some things that will help relieve some of that, give you some tools to help lower some of that stress level. This is my first outing with Justia. I'm delighted to be here, delighted for the invitation to share this time with you. I'm excited to spend this time with you, and that's true whether you are here because you love talking about writing every bit as much as I do, or you're here for the credits. Whether you're here because there's a particular aspect of your practice that you think a session like this might help give you a boost in, or because someone further up the feeding chain up in your shop has suggested that you might need a boost in that, whether you're volunteering or voluntold, as they say. I'm not proud. I'm glad to have you under any circumstances. And my hope is that you will find the program interesting, involving, practical, useful, not pie in the sky stuff, maybe even a little bit provocative, and even mildly entertaining from time to time. So let's start with this, okay? Just as a scene setter for you. When it comes to their writing, lawyers have a certain reputation, and it's not really a good one. Lawyers often put, and you know this, too many facts, details, arguments into the things they write. And by too many, what I mean is too many for that particular thing, for that particular document they're drafting, for that particular thing they're trying to accomplish, for the particular audience they're trying to advise or inform or persuade. So too much stuff. okay, for that particular task. That's one complaint. Here's another one. Lawyers often use too many words to say the things they want to say. Okay, you're aware of that too, I suspect. In a concise phrase, lawyers are not concise. Now, both of those traits, too many arguments or precedents and too many words to say what you're saying, can cause problems for you, can keep you from being as effective a lawyer, writer as you want to be, as you need to be. So this is a chance to do something about that. What I'd like to do with you is talk about both of those issues, saying too much and taking too long to say it, under one umbrella. So let's see if we can tweak some of those traits and habits, nudge you away from some of those default settings that lawyers tend to have and that tend to get in their way, and also to get rid of some of that stress as we proceed. What we're going to call it, what we have called it, crisper, clearer, tighter legal writing. What stays, what goes. We're going to spend, can you all see that? I hope you can. Nina, tell me if there's any problem on the tech side with that. We'll have a conversation throughout the day.
Looks great, Rick. Thank you.
Terrific. Thank you. We'll spend about 90 minutes together, as Nina said, and I invite you to ask questions, raise concerns, share your own insights, workarounds, tips, traumas, any of those things. I am a discussion leader. I call myself that. I try not to call myself presenter, and I certainly never call myself lecturer. If all you've got is me for the hour and a half, I think I have failed you. So I want you to participate. Nina will be filtering questions and sharing them with us as she thinks appropriate in the appropriate times. And again, we'll have some Q&A at the back end as well. When I say a discussion leader, what do I mean? Hoping not that. Certainly hoping not that. Okay. I could be happy with this. And frankly, I'm even happy with this. I mean, we got a room full of lawyers. You got to expect there's going to be some disagreement, right? So please contest what I say, challenge it, disagree with me, disagree with one another. That's what makes for a better discussion. Okay. What do I anticipate as your takeaways today? A couple of things. Greater awareness, first of all, of the lawyer's tendency to write too much, to say too much, and to take too long to say it. If you're not aware of it, it's hard to address it, hard to fix it. So we'll talk about raising that awareness. Greater awareness of how the lawyer-writer mindset, those default settings, contribute to the problem, okay? We'll suggest some ways to think differently about the writing process and your role in the writing process, what you're trying to accomplish. I'll raise some warning flags with you. You may raise some of your own as well, please, about particular stumbling blocks in your legal writing process. And we'll pair that up with some specific strategies and tips for being more concise, for being more effective writers. My hope in all of that is that you come away with greater confidence, justified confidence, please, greater confidence in your writing, and in the writing and editing choices that you make. For those of you who also have supervisory roles in your shops, I hope you'll have come away with some tools to help others in your shop achieve those goals, clearer, crisper writing. My hope is that that will be something you can take back to your shop, will give you vocabulary to discuss it with other people in your shop, so that we're spreading the word and getting better writing as a result. And then finally, I hope to lower your stress level, as I said, in the way you approach the legal writing that you do. So all of that in just under or just over 90 minutes, depending on how things go. You'll get that. Plus, you'll get CLE credits for those of you who qualify, and we'll get you back to your day pretty much on schedule. So that's all of that in just 90 minutes. What could be better? Oh, one more thing. None of this will be on the final. Okay, just wanted to clear that up and lower that stress level for you as well. Okay, so let us move on here to our first section. When lawyers write, what can go wrong? Let me give you a couple of scene setters to discuss what the issues are, what the problems are, and see what we can do about them. Here's one. Used to be one commandment. Which one of these sounds like you? You will probably start to anticipate my biases here, but which of these sounds more like you? Have you been in this position, or the people you've written to been in this position? You're just drowning them in stuff. How about this? Extra credit for anybody who can find a period before the last line. I will save you some time. There is none. There is only one long sentence. Now, I'm a bit of an optimist. I think that most of the time, most people, even most lawyers, would like most of the people they're writing to understand most of what they're writing. If that's the case, why would you do this? Why would you put all that into one block of unbreakable black-gray type? Okay. Here. How about this one? Does this resonate with you? Yeah, take your pick. Take your pick. We'll talk about this in a little bit. And then finally this. This will be on 2 screens and page 3 in those of you following in your workbooks. I've got 2 columns here, how lawyers often say it and how most other English-speaking humans say it. If you find yourself using a bunch of those things on the left-hand side, or either on this slide or this one, you might want to consider adjusting that a little bit. And we'll return to this one later. But again, just as a scene setter, I wanted to acquaint you with this and see how many of those left-hand side phrases are phrases you use a lot and maybe want to use a little bit less. Okay. Don't take my word for it. How about this? This is courtesy of AI, ChatGPT. Why write it like that when you can write it like maybe this? Now, you'll notice what I've done here is alternate really 2 different kinds of examples, the examples of too much stuff and the examples of too much phrasing, too long phrasing, too many words to get the stuff out. And those are the 2 things we're going to be discussing during the day. We're going to be talking about both of those because lawyers go astray, it seems to me, in both of those areas. And so let's go to here. And in general, ways that lawyers go astray: their writing is too long, often too late getting to the thing they want to say. It's too loosely organized. And to lawyers, we're going to concentrate on a couple of those, the long and the lawyerish, and in some degree, the late as well. The result of all of this, of these kinds of habits, maybe you'd rather not have your work considered wordy, unclear, pompous, and dull. But if that's not enough disincentive, try this one from Goldstein and Lieberman back some time ago. Yeah, pick your favorite there. You like weaseling, labored, bloodless, incoherent, archaic, any of those. Now, here's the thing. These were both from some time ago. And as you know, there has been a clear writing movement in the legal profession, which has made some progress over time. And my hope is that you are part of that progress and contributing to it as well. I'd like to think over time that gap has narrowed between writing as lawyers and writing to be understood and clearly. But that brings me to a second key gap and that'll be key really to our discussion today. I'd like to offer you 2 propositions, see what you think. Proposition 1, okay, you're probably pretty good at your area of the law. You've got training, you've got experience, you may have had good mentors, you've had on-the-job practice doing the things you do, and you've spent time at it. You've gotten better at it, and you're good at it. That's proposition 1. Proposition 2, you may not be quite as good at communicating all of that you know, communicating it effectively, communicating it appropriately for the particular document you're writing, for the particular audience you're trying to reach, for the particular purpose you're trying to serve. Closing that gap in your legal writing between what you know, your subject matter expertise, and how well you're able to convey it, your communication skill, is what we're about today. And we're going to focus on these 2 particular parts of it, the writing too much and the taking too long to say the thing. Okay? So that's basically our our goal for today. Let me show you that it's not just lawyers who have this. Stephen Sondheim. I am, so far as I know, no relation to Mark Eden Horowitz down below there, who's the writer. How many of you also find yourself hiding behind a lot of chocolate sauce in the legal writing you do? Now, I should tell you, you will see not just Stephen Sondheim here, but some other people you wouldn't expect to see in a legal workshop and a legal writing workshop. There's a reason for that. I think that writing is an art. I think that even legal writing can be an art. And so I think it's useful to us to hear from other artists in other fields who may have things to contribute that can be useful to our understanding and our improving what we do in writing. So we'll have those dotted in from time to time during the course of our time today. But if this is the only workshop you've got this year that has Stephen Sondheim in it, so be it. We can live with that. Anyhow, legal writing is an art, seems to me, but it's also a challenge. In fact, several challenges, and we've discussed or at least highlighted what those will be. Too much information for the particular task you're doing, and too many words to convey that information. So we're going to split our discussion into two parts. Call it Concise 1 and Concise 2. Does that work for everybody? I hope it does. I cannot see you, so I'll assume you're nodding your heads vigorously and smiling. Oh, but I should tell you, I've got a small medical condition. I see people with their hands up in the air and volunteering, even when they didn't realize their hands are up in the air and volunteering. So if I happen to say you there in the back, yeah, go with me. That's fine. So Concise 1 and Concise 2 is what we're going to talk about. Let me start here. We call it What Stays, What Goes, being Concise 1. And let me start with this. In my full day sessions, I tend to offer people these 5 observations that may be self-evident, but then 5 legal writing challenges that go with each of those. And I'd like to focus on the 2 in red today. For our purposes. People feel bombarded. Can you leave anything out? And people are busy. Can you get to the point? Okay. So again, this is Concise 1. What do you choose to include in the document you're writing, and other things you can leave out? Second half of our time together, we'll get to the one that's below it. Okay. So that's how we're dividing up our time. What do you choose to include? Are there things you can leave out? Or putting it another way, how much is enough and how much is too much? All right. I also suggest in some of my fuller day sessions a whole series of these Rick's Rules of the Road for Less Than Effective Legal Writing, and I put them up as warnings, sort of highlighting certain lawyer-writer mindsets that can be problems for you. One of them, it seems to me, is this. We tend to think, I've got to include this, and I've got to include that too. And for that matter, probably the third thing and the fourth thing as well. Second one, also a rule of the road for less than effective legal writing and how you think about it, is probably this one. And how many of you are subject to this particular state of mind? I can't cut that. I might need it later. Yeah, it's not always easy. It truly is not. Then again, you're not the only one struggling with it. Take a look here. Tend to be too wordy, which impacts clarity and persuasiveness, putting too many things in. And my guess is, and I collect these from questionnaires I put out before some of my full day sessions. What's the hardest part of the writing editing process for you? And look how many of these there are. And I could have given you a couple of dozen more of these. Being complete but concise, trying to be concise while at the same time including all the relevant facts. Being concise while providing enough details. This is an ongoing issue for us as lawyer writers, and I'm assuming you feel that pressure too. Let me say this on that score. When it comes to coaching and writing, I am not an always or never kind of person. You will see this as we go through our time together. I don't have a lot of hard and fast rules. Yeah, I think it'd be good if you spelled all the words right. People will judge you. I think it's good if you know how many versions of the word it's there are in captivity. Not despite what you might have heard. Check our workbook. You can find more about that sort of stuff. But when it comes to writing, I think a lot of things depend on the circumstance you're in. A lot of writing decisions including the decision what to include and what to leave out, it seems to me, are situational. What will work most effectively for this audience, for this document, to accomplish this particular goal. So I'd like to spend a couple of minutes now talking with you about some of the common situations. If you want to call this situational writing, I'm fine with that. That's a good takeaway phrase for what we're talking about. For some of the common situations you face as lawyer writers and some typical lawyer responses, okay? There is, I believe, an urge to over-include. Not surprising. Think about why that is. Think about why, and if anybody has a comment they want to share with Nina, who might want to share it with us, but I'll suggest a couple of them to you. Let's hold on to that for a second here. That gets you to this particular place, being concise but complete and trying to wrestle with those things. I think there are some good reasons to include things in your document, obviously. There are court requirements. They want the jurisdictional statement. They want the procedural history. I'm not about to advocate revolution for you. You need those things. They require them. You have to put them in there. Jurisdictional claims, retaining the right to raise something on appeal. It may be a strategic and or tactical decision to include something so that you have the option of dealing with it in greater depth later. Understand that. Some things are simply smart or logical to have in the document you're drafting. A clear call to action, if that's pertinent. The strongest arguments you can make, persuasive data or solid precedents. Okay, all those are good reasons. Beyond those, though, it seems to me there's still a tendency for lawyers to over-include. And again, I invite you to offer your own. Lawyers' tendency to over-include. Why is that? I think a couple of reasons, and again, please offer up your own if I've left some out or you have some others you want to share. I think we often try or think we need to use it all to justify our research. We found the stuff. We got to let somebody know we found it all. We did the work, so we put it all into the document. Second, sometimes I think we use it all to justify our tuition at law school. We paid our way there. We know how to do it. We know how to find things. We're going to show that we've actually learned it. As you can tell, I'm a little skeptical about that as a justification. Third, use it all because you really haven't considered who your audience is for this document in this situation, what your goal is for this document in this situation. Another reason you're used to using it all is because you came out of law school where you wanted to nail those exams, and issue spotting was a major way to get your grades up where they ought to be, is by finding everything that's possible to find and by getting it in the blue book. Again, not necessarily what you want now. For instance, don't write more than you have to. But again, that goes against some of our training. So again, to the extent you can readjust your default settings, your mindset, I think that's a helpful thing. Don't write more than you have to. A couple of others. Use it all, you might think to yourself, and I can let my supervising attorney, senior partner, make the call on which should stay and which should go out. We'll return to that one in a minute because I think it's worth a little more discussion. Use it all because, the famous Blaise Pascal is the person most often attributed with this. I wrote it long because I didn't have time to write it short. And I know we're all under, and you're all under, certainly, time pressures, and sometimes you just don't have time to slim it down. Granted. Then there's thinking you have to reply in full to every argument your opponent makes, no matter how flimsy that argument is. I'm sort of a fan of the quick flick away if you have to deal with it at all, rather than letting your opposing counsel really set the tone for the entire discussion by their document and their arguments. So there's that. Another one, use it all because you've fallen in love with your writing. It's been known to happen. Can you see how these approaches, these tendencies to over-include, can lead to problems? I hope you can. You may even recognize some of them in your own work. Does anybody recognize this? Does anybody know what those letters stand for? I will leave this up for a second in case somebody wants to jump on the Q&A and provide an answer to Nina. But let you think about that for a moment. TLDR. While you're thinking about that, the cat is optional, by the way. While you're thinking about that, let me go to this one. We'll return to TLDR in a second.
Devin, and we have an anon who said, too long, didn't read.
Too long, didn't read. Exactly. Who was that? And thank you.
That was Devin, as well as an anonymous attendee.
Thank you, Devin. Thank you, Anonymous. Glad to hear from you. Too long, didn't read. You go to all the trouble. If the thing you're writing doesn't get read, what's the point of all the work you put in? Maybe you want to do a little more work on the slimming and trimming side first. Make sure you're getting across to the person you're writing to. Thank you. How about this one, though? Have you run into a situation like this where you write it all, you put everything in, and your boss says, I'm actually paying you to make those calls. We're going to come back to this in a minute because I think it's important. All right. But all of those are reasons and situations you can find yourself in that keep you from being as effective as you can because you feel the urge to over-include. So what I'd like to do is offer you a counter-argument to the extent you recognize yourself in any of those, a counter-argument, and call it an alternative approach. And to do that, I'm going to call on the famous lawyer, Georgia O'Keeffe. I'm lying about that. Of Georgia O'Keeffe, I stole this particular saying off the wall of the Georgia O'Keeffe Museum in Santa Fe, New Mexico, some time ago, by which I don't mean that I pried the bronze plaque off the concrete, but I do mean that I took a notebook and wrote it down, and I've been sharing it at workshops pretty much ever since. I think it's one of the best, most useful comments about the writing process that I have come across. And she wasn't a writer, she was a painter. But details are confusing. It's only by selection, by elimination, by emphasis that we get at the real meaning of things. And I think she's right. I think good writing is not always about adding stuff. Adding stuff can often make your writing less good. It gets in the way of the good stuff. It can keep your writing from being clear because more is not always better. It can make your writing less accessible. Okay. It can make your writing less focused where you want the focus to be. Say you go into a theater to see a play. You've got 20 people on stage and you've got 20 pin spots, one on each person. Where do you look? Who do you focus on? They're not giving you any help in setting it up that way. You're looking all over the place. It's harder to identify the core, the thing they want you to look at most. Same thing with writing. By selection, by elimination, by emphasis that we get at the real meaning of things. And putting lots of stuff in can even suggest that you're lacking confidence in some of your main points, in your strongest arguments. Okay, we can talk about that a little if you'd like. And then there's too much of a time suck to even bother with. We're back to TLDR. Yes, there's time pressure on you, absolutely, and that's true. Particularly, I suspect, in the writing process. But there's also time pressure on the people you're writing to, on the law clerks, on the judges, on opposing counsel, on your clients. And being aware of that, I think, makes you and being willing to adjust to that fact, makes you a more effective communicator, a more effective lawyer-writer. So how do you deal with it? How do you make those better decisions? Okay. Let me give you a moment to think about that. And again, if anybody wants to come in on that with some of your own suggestions on that, I'll be happy to hear them.
We have a couple comments in the Q&A. So the first person, this is an anonymous attendee, says, law clerks may like to avoid that the parties ask for reconsideration because the court omits arguments. Because of that, I feel they add more details than needed. So just a comment from Anon there.
I think that can be the case. That can be the case. And I've had different law clerks in my sessions, DC Bar in particular, where, the first three said, no, we want you, if we see 40 arguments, they were being hyperbolic, we think of desperation and we get bored. And so we'd rather see fewer. But then I had one law clerk after that who said, no, my judge wants to see it all. I want to see it all. So give me everything you've got. I often have a longer discussion in the full day sessions with some video. You'll see a cite to it in the workbook, University of Virginia Law School, of a comment secondhand through John Roberts, who's gone on to do other things, as you probably know, about just, land your punches, just use your strongest arguments. And we have good discussions about whether that's true in all cases, or whether you just go to some smaller number of stronger arguments. My job in that discussion is typically to nudge you off whatever your comfort point is. If you think it's always the case that you throw everything in, I want you to reconsider that. If you think you've always got to cut down to your best three, I want you to be aware that there are cases where you just threw arguments 6 and 7 against the wall, hoping it'd stick. And what do you know? The clerk and the judge went for argument 6. So I don't think there's one clear answer on that. But my goal there is to let you know that there are arguments on the other side of where you are currently standing. Okay, Nina, the second question. I hope that was okay. Yeah,
Absolutely. Eric comments, just kind of reiterating what you were saying, that it is the responsibility of senior attorneys when they get a rough draft, they need to understand that they're presented with what's available to pare down into a final version. It's not a final when it starts.
I think that's right, and we'll be discussing in just a couple of minutes ways to make that a more effective collaboration and a more helpful understanding of where it is in the process. So thank you for that. Both of those were really helpful. Let me see. I was asking different ways to approach it and different ways to make a better decision about what's in and what's out. One of them is just sort of deciding, what do you got to have? If you had to pull a thread through stuff, what's your got to have it? If you had the elevator pitch, if you were at a stoplight and somebody from your firm came up or from your office came up at the other lane, you had just enough time to get the window down and shout across. What would that thing be that you shout across? What's the core? What's the thing? Some people have said, what would you tell your mom across the kitchen table? If that works for you, go with that. But some way of narrowing down the scope of what you found to what you think is most important. Let me show you another way to think about that, if I may. Oops, there it goes. A colleague of mine who does editorial writing and editorial workshops, I've sat in on a number of those and did a number when I was doing column writing myself. He suggests this. What's your bouillon cube? When you boil it all down, what's the thing? What's the core? That's the thing you have to protect. That's the thing you have to highlight. That's the thing you have to make sure doesn't get lost in the underbrush or the overgrowth, that you have to make sure that they focus on that. Is that easy? None of this is easy. None of this is easy. It takes great control. It takes great self-awareness. Let me show you one from one of my earliest workshop attendees in DC. She's able to get outside her own lawyer-writer head and get herself to the other side of the table, to the other side of the desk. She's not writing to satisfy herself. She understands. And so what would be satisfactory and really impressive to other lawyers, not all the writing you do is to other lawyers. Not all the lawyers you write to are as expert in that field as you may be. So how do you adjust to that? How do you keep from writing too much for your non-lawyer or non-expert audience? First step, of course, again, is to be aware of that fact, to be open to that possibility that that's what you're doing. Okay? Had this from someone a couple of months ago, and I've been sharing it since. I think it's great. What do you make big? What do you make small? And I would add to that, and what do you leave out altogether? Okay. If Georgia O'Keeffe is right, and I think she is, obviously, that selection, elimination, emphasis really matter and are key to making an effective communication, then I would argue that choosing is at least as important as including. Choosing what goes in is at least as important. And in specific situations, I would say, I would certainly opt for sifting over regurgitating everything you found, but I would further say that in specific situations, you use different sifters, if I can push the image a little bit harder here, of different fineness and how finely they sift. what they sift out, what they allow through. Those lawyer-writer challenges I showed you before, the two I highlighted, and the main thing is, can you adjust? Call it situational sifting, if you will. Who's receiving your document? What do they need to know now? How much time do they have? We're back to time again, TLDR. How much expertise do they have? How familiar with the case are they? Okay. Do you notice how goal and audience, which I've mentioned before, are woven into these? How central they are to these kinds of in-out decisions, situational decision-making. Let me rephrase these if I can, and just put them in through a reader lens, okay? Why does he need the information? How will he use it? What does she already know? How much does he want to know? What language and organization, will seem natural to her, okay? Again, what matters? What matters this time for this goal, for this audience? Quick question for you. Why is an executive summary called an executive summary? Called an executive summary because your boss is going into an 11 o'clock meeting, and what she needs from you right now is 3 paragraphs to run that portion of the meeting. So that's what you want to give her, is 3 paragraphs for that portion of the meeting. Now, next week, same you, same boss, she may want the 10-page background memo. Okay? Can you recognize the difference in the request? Can you adjust to the difference in the request? Can you make decisions about what to leave in and leave out? Again, it's situational. Can you recognize the changing situations? Can you adjust to them? Okay. So to sum up where we've come just to this point, there's several different ways to get you to re-examine your habits that we've talked about, things that you've sort of default to, but maybe are not as effective in certain circumstances, and help you make better in-out decisions. There's another way, though. There's another way to help, and this came up in one of the comments we got a few minutes ago that Nina shared with us. Ask. Let me ask the people in the room who are assignees, people who get the assignments. My question to you, is it worth the trip down the hall, or its virtual equivalent for those of you working virtually, to talk with the assigning attorney before you've dug a hole too deep in a place you weren't supposed to be digging it? Is it possible to check in along the way, and this gets to the comment, with a preliminary outline or a draft, understood to be and recognized to be a draft, preliminary outline, to make sure you're heading in the right direction? Do you have the kind of shop? Can you make the kind of shop? And again, some of you may not be in a position to make that kind of shop. I understand that. Can you encourage that kind of shop where you do feel comfortable walking down the hall, knocking on the door, and asking a question? I've had one group in one of my sessions some time ago who mentioned that in their shop, they have something they call a clarifying question. That's the magic phrase. And that gives them permission to go down the hall and ask that question. It's not seen as an interruption. It's seen as a normal, helpful part of the process. I have a clarifying question. Is that something you can use? Is that anything anybody here has used or its functional equivalent and wants to share with us? But what was so interesting, useful about that comment was that it did keep that door open and avoid some of that misunderstanding about whether this is final or whether it's not, whether I'm digging in the right place or I'm not. Now, I have heard, you may have too, from occasional supervisors that it's a bit of extra work. You're giving them extra work. I'm going to turn to the supervisors in a minute. I think of the large amount of work you're sparing your supervisor by not having them have to go through it, rip it up, tear it up, or say the hell with it and do it over themselves. You're making less work for them. You're saving time for both of you, it seems to me. And I'm open to anybody who has a comment on that.
We have a comment from Janine. Sorry, Rick.
Please interrupt every time.
She mentions that she thinks a great strategy is to ask the senior attorney for samples of the kind of memo they want, then see whether those samples are more thorough or more concise.
And match up. Yeah, templates are useful. Models are very useful in that way. And again, I think that's a great idea. Thank you. What is also true is that supervisors may need to adjust their thinking a little bit. As I said, I've heard from some supervisors in some sessions that they think it's taking time away from what they need to do to be open to those questions. Clearly, I'm not a fan of that way of thinking. Have you made your intentions, supervisors? Have you made your intentions, expectations clear? Are you aware of the hurdles that are there? Time hurdles, research hurdles, difficulty of getting the right people connected to get the information. Are you aware of the writing context you're assigning, the complexity, the competing deadlines, staffing issues, things of that sort? And have you had any initial contact? Have you had any contact since the initial assignment was handed out? Have you headed off any confusions or misunderstandings? I think it's important. I did one session a while back in DC with lawyers and some paralegals, and including some senior people. And one of the senior people said, well, his door is, he welcomes it. And by the end of the session, I'd say half of the paralegals were looking to sign up with him to go work for their firm, because the miscommunication, the missing communication is so prevalent in so many shops that to the extent you can head that off ahead of time, you're doing both of you a service. You're doing the shop a service as well. You're coming up with a better document. So let me thank you for those comments. Let me think here. When it says one again, does that mean we have another one, Nina, or is that the same one that's still up there?
Yeah, we had another person just comment, echoing kind of the sentiment that you're mentioning, that it will save supervisors time in the long run if they support and train their supervisors.
Okay. I should trust you to just share the ones that won't be repeating what we've gone over. No, we're a new team together, Nina and I. We'll get it there. This is terrific. Let me show you this one. I told you about it a few minutes ago. I said we'd come back to it. I had a either senior associate or junior partner in one of our sessions who offered a way through this. The problem here being the lawyer, the associate, wanted to put everything out there, and the senior says, no, I'm paying you to make those choices. What she did, and see if this might work for you or some variant of it might work for you. She basically set up the lawyers she was supervising, the associates she was supervising, into three tranches based on their level of experience, say 0 to 3 years out, 3 to 6, more than 6, 6 to 9 or something, okay? And for each of the tranches, she had different expectations. For the least experience, the 0 to 3, she wanted them to give her everything they had found. She wanted to make sure, given how new they were, that they hadn't missed on something, that they hadn't failed to look at something that she thought needed looking at. So with the 0 to 3s, give me everything. Okay. At the other end of the spectrum, with the 6 and ups, she said, give me a document that's as close to final as you can make it, so that if I like what you've done, I can hit send and it goes out. With the middle group, the 3 to 6s, she split the difference. She said, give me a document that's fairly close to ready. But if there are, say, a couple of other issues you thought about raising and decided not to, drop a note, give me a side memo about what your thinking was. Maybe even give me language so that if I decide, yeah, I think they ought to go in, I'm ready to go. I can cut and paste, put that in, and then I can hit send. So she had 3 different sets of requirements, expectations for 3 different sets of lawyers based on their experience. What's key to this? She let them know. She let them know what it was she was expecting from each of them. And that gets exactly back to the point that Nina shared with us a few minutes ago about understanding whether it's draft, understanding whether it's final, whether it's in progress, and what stage of in progress. The communication on that point, it seems to me, is essential. In her case, the one I'm just telling you about, she seems to have communicated this stuff in advance and sort of as a general approach to the work. But certainly you can do a similar thing on an individual assignment as a supervisor. This is what I'm expecting from you. My hope is that that door is open and that the associate can walk down the hall or drop a note or knock on the door, and that the supervisor can communicate what the supervisor is looking for. I think that's a plus for everybody. It also lowers the stress, doesn't it? Speaking of stress, we do this. There's one more factor in deciding what to leave in and what to leave out, and that is stress. One is this: I love everything I wrote, and it's stressful for me to have to take it out. I'm sorry. The other stress is that because it's such a struggle to get it on the page, once I like it, it's impossible to take it off the page. So I want to spend a couple of minutes with some suggestions about how you deal with that. Again, I'm open for comments and suggestions from you guys. Let me offer a couple. I think the fear, tell me if I've got this wrong, I think the fear is that you cut something out of your document and you change your mind later. And you decide you want it, and presumably it's gone off into the ether, never to return and never to be recaptured. Well, there's ways to deal with that. You probably know several of them. You may be using them. One is sequential drafts. If you keep it around, you can go back to draft 2 when you're on draft 3 or 4 and rescue that paragraph, that argument that you now decide you want in. Okay. Another is just drop a footnote, stick it in the margins, put it in review. So you have it still available to you, but it's no longer in the main text. Other people have put it in different color or put it in italic, so it's there but not there. So you can read past it, but you still have it if you want it. I've had people in sessions describe having it as a parking lot, having it as a cutting room floor, having it as a warehouse. Any of those as examples, ways to think about it, that it's out of the document, but it's retrievable. And again, to the extent that a lot of what we're talking about is what goes on in the lawyer's brain, getting rid of that stress that I'll never be able to find it again if I cut it now can help you make the decision to cut it. Here's an interesting thing, and see if this squares with what your experience is. I raised this question one time in a session in Boston Bar, and a woman raised her hand and she said, I think she was the one who used warehouse, I'm not certain of that, but she said her experience, and see if this squares with your own, is when she cut something out of her document, I think she said 95% of the time it doesn't come back. Having taken it out of the document, she realizes she could live without it. Does that, and I've raised that comment with other sessions I've done since, and I get similar kinds of reactions, that it's 95% of the time. It's getting over the psychological hump of taking it out that allows you to see that you didn't need it in the first place, way more often than not. And so I offer that up to you as well, and see whether that might ease some of the stress that you might have in making those cuts.
And we have a question from someone who's a senior paralegal. They ask, how would you go about deciding what to keep and what not to keep? Obviously, there's situation to situation, but what is kind of your general tip about that?
First, have you gotten, I mean, this will fold back to some of the discussion we've had. Have you gotten any kind of guidance from the person who's given you the assignment on or as somebody suggested, are there models, previous versions of the kind of thing they're looking for that will give you an idea of how inclusive or how concise you want to be, how exhaustive or how concise you want to be? So that would be sort of first level. The second level would be, do you have a system in your office where you can ask that question before you go to the trouble of writing the lengthier draft that's way more writing than you needed to do? Can you do that? Can you provide, here's another idea, can you provide an outline when you're not yet at the fully fleshed out phase? Can you offer an outline up to your supervising attorney? Here's what I've got. Here's my general approach. Does this fit with what you've got in mind? And that's another way to get sort of earlier guidance. What you hope to avoid, it seems to me, and it sounds like this may be an issue, is coming up with something that you've done full and being told, this wasn't what I was looking for. And so I think any of those things, and again, open to anybody else who's got some others, any of those things I think would be a way to try to prevent that from happening. Does that help? I hope it does.
Yeah, thanks, Rick. We also have another tip that's being shared by James. He says, when I think something might be unnecessary and I'm not sure if I want to fully remove it, I put a pound symbol before it. I also use 1 to 3 of these symbols to indicate how necessary or unnecessary it seems to be. By the end, I almost always find myself deleting these marked passages or moving them to bolster a more appropriate section.
Nice. I like the gradations you've got there, James. That's nice. I may be sharing that with credit. James, thank you. That's a good idea. Thank you, Nina. Anybody else? Okay. Let me then go to this next slide. Keep them around. Keep them for reclaiming. I can tell you that I had someone in a session a while back who had a file. He didn't call it Ditch Your Darlings. He called it honest to God, he called it The Brilliance of Me. When he came up with some phrase he was particularly fond of, thought was really great, but, didn't actually fit in the document he was writing, he would save it under The Brilliance of Me. And I was never sure, he didn't say, whether this was done in the expectation that someday there'd be some document that actually called for this thing, or whether just some night he'd be sitting home by himself, feeling low, and just take it out and say, damn, I'm good at this. Again, whatever works for you, works for you. So if Ditching Your Darlings or The Brilliance of Me will get something out of a document it doesn't belong in and can save it for a later day, go for it. Absolutely. Let me close up this section in just a moment here. I gave you Georgia O'Keeffe. Let me also give you Jamaica Kincaid, the novelist. What I don't write is as important as what I write. And I would ask you, as your new mindsets, not all facts are pertinent facts, and not all arguments are useful arguments. And I would add to that at the moment for this document, for this audience. And the second one, make everything earn its way into your document. I'm not saying leave everything out, obviously. You'd have a blank page. What I am saying is there ought to be a little bell here, a little bar that it has to clear, that has to ring the bell that says, has this earned its way in, rather than our frequent default setting as lawyer writers being, I found it, it goes in. I know about it, therefore I'm sharing it. Can you make that little bell go off to remind you to make it earn its way in? Okay. Make it clear that bar. Okay. So we come to the end of our first section. You've decided what information makes the cut. Now what? Well, you probably want to make sure that you don't use too many words, too many cumbersome sentences, even overly wordy phrases to present that information, because wordiness can get in your way too. And that brings us to concise number 2. What stays, what goes, being concise too. And again, your questions, comments, tips, most welcome. Thank you. And thanks, Nina, for bringing them in. I told you we had those 5 observations, and 2 and 4 are the ones I'm highlighting today from our full day classes at Prime Pros. People are busy. Can you get to the point? And again, the second one, first one was what do you choose to include? And the second one, equally important, it seems to me, in some ways, how do you write the things you've chosen to include, and other ways to tighten those things up? All right. The distinction between first half of the day and second half of the day. And again, one of our rules to be avoided, not true. Likewise this, not true. Dick and Jane for lawyers, or something like it, academics. We fall into that trap. We can. Take a look at this. This is on page 13 of your workbooks. I just came across this a short time ago from Roland Klinkenborg, who used to be an editorial writer at the New York Times. For those of you old enough, he used to write the Sunday wonderful sort of nature turning of the seasons kinds of things, noticing things nobody else noticed, writing about them in a lovely way. He has a book out called A Few Thoughts on Short Sentences, or A Few Short Thoughts on Sentences, as you'll see here. Goes on a little bit, the land of linguistic barbarism. Yeah. And here, several short sentences about writing. That's what it's called. And the punctuation is his. I wouldn't dare tinker with that. All right. The result of all that, it seems to me, can often be that. We're the lawyer. The photograph is not mine. The headline is, we're the lawyer. We are shining the light of our beneficent wisdom on a grateful population below. And not only that, but we're bombarding them with rays of not only knowledge, but also words that may not actually connect with them. I don't think we want to do that. But lawyers, sounding like lawyers, can often be wordy, and not just in the urge to over-include information, but even in the particular wording or phrasing they use. So here's this. To get us started, set the scene for this second half. Same idea in half the words. That's a good thing. That's a good thing. Not only because you're dealing with word or page limits, but because you're trying to keep people's attention. For instance. So it's for effectiveness. Whether that effectiveness is to persuade or inform or reconcile or comfort or whatever your goal is that time out. Too many words can get in the way. Let me toss this at you. Take a mental pencil. Take a look at the left-hand side. This is in page 14 in your workbooks for those of you looking over there. Tick off a little check or X mark. Maybe a pound sign, James. Pound signs. For each of those phrases that you use on the left-hand side. 2 of them, 3 of them, 5 of them, 10 of them, almost all of them. Take a look at the right-hand side and see whether those might be perfectly suitable substitutes for that left-hand string of words. Okay. Do you recognize the left-hand column more than you would like to, given what we're discussing? Maybe worth considering. You may want this piece of paper sitting near your desk someplace. Or you can ask AI, ChatGPT. Couple of examples. You'll find them on fuller versions on page 15 and 16 in your workbook. But you can write, here's a prompt I've sent to them. Me a dozen wordy sentences and edits to make them more concise, key phrase here, without losing their meaning. That's what we're about here. Can you say the same thing, make the same points in fewer words, making them easier to follow? And you'll see the examples here and more of them. You can also, and some of you may have done this, I do a fuller module on AI as a writing tool in the full day sessions, but some of you may have taken a 500-word memo you've written and say, can you cut it down to 400 for me, and see what it does. Okay. Worth looking at. A couple of caveats for you here. I don't mean to suggest, in talking about what we're talking about, that shorter is always better. There are competing considerations. Which one's better? Well, it depends. If you're dealing with somebody who's a newbie to legal systems, that first sentence doesn't give them enough information, does it? What's a default judgment? So again, I'm not suggesting short is always better than long. As short as you can be without losing meaning, important meaning, context, consequences, advice. And then this one. These word counts are not the only measuring stick for length, it seems to me. These are both 10-word sentences. Which of them reads shorter? Which of them reads longer? Which of them is crisper? Which of them is more cumbersome? I think you'll agree with me that choice 1 with 10 one-syllable words reads tighter than the other one, which only has 3 one-syllable words, and, by, and yet, and everything else is multi-syllable up to including 4 syllables. How many of you read your stuff out loud? If you don't, I think it's very much worth considering. You may have to take yourself into a stairwell someplace if you share an office, but in any event, if you can do that, you will hear things that your eye won't see. If you find yourself taking a second or a third breath to get through a particular sentence, that should be an indication you've got too many words in that sentence. Or too long words in that sentence. I think of them, rather than words, syllables is one way, but I think of them as beats. How many beats does it take you to get through the thing you're trying to say? And those beats will be much more noticeable to you reading aloud. Or you can use on Word, you've got read aloud as a function. You can have it read back to you and see how bored you get by the time you're at the end of the third big phrase in that sentence. That's another way. Be the listener instead of just the writer. So what I'd like to argue with you, to you, is that shorter isn't necessarily better, but generally speaking, yes. And generally speaking, aim for it. Okay. So let's look at a couple of ways in our next half hour or so. Some specific ways we tend to miss that target of being tighter, crisper on the detail level here. We're concise number 2. And see which of them applies to your own work and whether you can make changes. One thing I want to stress, which is why I'll come off the share screen for a second, is that none of these things we're going to be talking about here is by itself a game changer. No one phrase tightened, no one 5-word phrase turned into 2 or 5-syllable word turned into 2 one-syllable words. No one of those changes is going to alter the entire document. Here's the thing, though. If you have 2 or 3 of those kinds of things in a sentence and 3 or 4 sentences in a paragraph and 3 paragraphs on a page and 10 pages in a document, the cumulative effect of all of that, the cumulative effect is a slog for your readers. So while no one of those things is a game changer, the accumulation of them can be. And so being alert to those, looking out for those, to avoid that cumulative impact, I think is really important. And so that's what I urge you to do. Now back to our regularly scheduled screenshot. One of the potholes, throat clearing, where your sentence sort of has to rev up before it gets to the point. These, for instance. Can you see how each of those can be at a minimum tightened? And in some cases, probably just ditched altogether? You're clearing your throat before you're getting to the thing. Okay? Try this one for a second. I'll show you this, and then that sentence is 39 words long. Look at the first half of that sentence. If we were in an actual in-person class, I'd have you take out a notebook and try to scratch that down. Inferentially, the decision of the Champlin Court can be read to stand for the proposition. Anybody want to take a quick crack at what you might do with that?
We have a question from Margaret. This is not directly related to this, but it is about kind of when you are making things more concise. She asks, how do you keep from string citing when you're cutting out other items?
That one, I don't have a certain answer to that. May I throw that out to the room? I don't deal with citation form and as often, and Blue Book kinds of things as often. What I would suggest, if you're looking for making the main body of the document, and tell me if that's what the question means. If you're looking to make the main body of the document tighter, then dropping those into footnotes to the extent that the place you're writing for, the style book you've got, the court you're writing for permits that. That's another way to do it. The question of whether each of those sites is relevant is a judgment call, obviously, on how important they are to the argument. It gets back in some ways to the thing we were discussing in the first half. Can you land your punches and just put the main arguments in that you need rather than extraneous ones? I'm not sure I'm answering your question. I'm vamping a little bit in case anybody else wants to come in with more precise advice on the string site. If anybody wants to do that. But does that help the questioner, I hope?
Thanks, Rick. Yeah, that's great insight. Generally, I think that's great to apply. We do have a couple folks who've actually started to edit that passage that on the slide. So let's see. We have one anonymous attendee who says Champlin holds that X, Y, and Z. So just shortening that up. And then we also have Jennifer who shortened it to Champlin holds that owning property in a county does not establish venue where the plaintiff's employees only occasionally work on that.
Rather than on a sporadic basis. You've gotten rid of some of that as well. Thank you, Jennifer. Yeah, I think both of you are onto good moves in the first half in particular, because look at all that throat clearing phrasing there. Inferentially, the decision of the Champlin Court can be read for the proposition. I'd make one tweak in both of your suggestions, which is this is the answer that Garner provides. Champlin suggests rather than holds, because it's not quite, at least as I read it, inferentially can be read is a little bit less concrete than I would say a holding is. So I would probably go with, not that Garner needs me to say I'm agreeing with him, but I would probably go with suggests rather than holds there. But the rest of those changes both of you made, I think, are exactly right. Rather than the decision of the Champlin Court, Champlin in italics is the name of the case, which means the name of the decision in the case, which means the decision of the court in the case. Why do you need all that? Get rid of it all. So I think both of you are onto something, and I like, again, the only occasionally instead of on a sporadic basis, tightens that up as well. This goes from 39 words to 21 words with these changes. I'm hardly suggesting that every sentence you write can be cut virtually in half, but be alert to the possibilities that some can. And even if you take out small pieces, again, the cumulative effect. So thank you both for that. Thank you. Thanks, Nina. Let me see. These were throat-clearing choices to get started a sentence. Let's try some speed bumps that slow you down in the middle of sentences. Take a look at these, if you would. Do you see things you might be able to get rid of? Let me help you. Again, anybody who want to take a crack, we'll just do the first one for the moment. Add a quick rewrite of that. Rather than with respect to my work, the emails are in the context of. How about my work emails deal with discussing legal issues as a start for that one. My work emails rather than with respect to in the context of. So, the second one, sometimes I'm not sure where to start in terms of organizing. This is in the context of pleadings and occasionally with motions. How about sometimes I'm not sure about how to organize pleadings and, if you want, occasionally motions. Why do you need this as in the context of? Why do you need in terms of? Why do you need with respect to? Each of those, I think, can go out. Like that enormous thing we saw at the very start of our day from the California Penal Code. I've had people say, but all those details were necessary. And I say, yeah, but where does it say they all have to be in one sentence? In one unbroken block of type? What if a chart or bullet points can get you there? Shorter phrases, all the information you need, but in a form that is more accessible, more likely to be understood, assuming, again, that you want to be understood. Okay. Another one for you. What might you do here instead of The manager said he would implement a rearrangement of. How about rearrange? Instead of a verb and a noun and another preposition, implement a rearrangement of the workload. Why not just would rearrange the workload? Go to a verb. Tighter, cleaner, more active, more powerful. Second one, would rearrange the workload. Yeah, there it is again. As an encouragement to. You've got a noun and you've got a preposition in there. What would be a logical fix there? Rearrange the workload, either, depending on what you think of encouraging, whether it's important or not. Rearrange to increase productivity, or perhaps to encourage increased productivity. But again, if you can look for those phrases, those extra nouns that don't need to be nouns, that can be turned into verbs without those extra words and extra beats, I think you do yourself a favor. Just to clench the point, you can do that too. Give you one more writing possibility here. Look at all the nouns in that first one. Take a look, for instance, at the very first half of that first sentence. I'll give you a moment, if Nina's okay with that, to let them take a shot at possibly coming up with a rewrite that goes verbs rather than nouns. Nina, we can chat in the meantime if you'd like and give them a chance to attempt something. Up to you.
Absolutely.
All right. Do you notice how many Asian words there are in there, Nina?
Yes.
And each one of those comes with an extra preposition after it.
Yeah, it kind of illustrates how easy it is to get wordy. Like once you start writing with that tone, it makes sense that you're just adding all of those additions.
Absolutely. So let me see if I have vamped long enough and you've been helpful.
I
This
don't
will be good.
see any.
Nobody, we'll give away the answer. That's okay.
Sounds good.
Instead of when making application for, how about when applying? I will not bother you to remember whether that's the ing form is a gerund or a participle. I can't keep them straight myself, and it doesn't matter for our purposes here. But how about when applying instead of when making application for? And then right behind that, how about when applying to modify rather than when applying for a modification of? Applying to modify. And then even in the middle of the sentence, instead of the inclusion of a summary sentence, statement, I'm sorry, how about including? Or we advise you to include. I have read of people who will do word search in their documents and look for Asian, will look for is Asian, will look for shun, T-I-O-N, and even S-I-O-N as an inclusion. So take a look at that second one on your own time if you'd like to. That is...
We do have one rewrite from Lindsay that just came in.
Good.
This is a rewrite. When applying for a local zoning modification, include a summary statement.
There you go. Do you see how you can do that? It's reachable. It's achievable. Often you won't have enough time. Sometimes you will. My hope is, and this will apply to everything we're talking about in this section, you may not come out of this session immediately doing these things we're talking about that I'm nagging you about. My hope is that maybe when you do your first rewrite, your first revision of it, you'll say, oh yeah, that was that thing. That's the bell going off. That's what he was nagging about. Let's do that. My hope too is eventually the things we're talking about in this section become muscle memory. And even your first draft goes to the shorter, tighter, crisper versions. The middle ground is that at some point you'll notice it in your first revision. You'll catch those things. You'll be looking for Asian, modification, making a contribution to, significant reduction in, installation of, all of those words. And you'll be on the lookout for those. And you can get rid of those. Okay? Easy ones. A trial by jury was requested by the defendant. Whitehick in Plain English for Lawyers has a he does working words versus glue words. He thinks there are too many glue words. I think glue is useful to holding things together, so I've tried to find a better word. The best I've come up with is connecting. But instead of a trial by jury was requested by the defendant, why not the defendant requested a jury trial? And you've gotten rid of some of those connecting words. Rather than the ruling by the trial judge was prejudicial error for the reason that, how about the trial judge's ruling was error because? And likewise in the second half, rather than with respect to issues that were vital, cross-examination on vital issues. You can do these too. One more pothole in the path of smooth reading, and we come to what is undoubtedly going to be the highlight of your day, which is Rick's Poetry Minute. All right. I did a workshop for the Oregon State Bar a while back, and I asked for some original writing in addition to, citing some of the writing experts and gurus. And so I decided to do one on the scourge of certain kinds of legal writing. In fact, I called the poem The Scourge. I will share it with you now. Here and after, here and under, rip the brain cells quite asunder. Silencio and arguendo, fun, but not a chance to mendo. Claimants may be on all fours, but who can judge above the snores? As words pile high and jargon flows, we rub our eyes, we hold our nose. No simple task to wrap one's teeth round give, devise, and, bequeath. And what attorney wants to face pursuant to the instant case? Comes now aforesaid inter alia. Now fess up, when did English fail ya? The forest lost behind the trees, we hack our way through legalese. Wherein, therein, therefore, thereby, the reader reels and wonders why, when normal words can still convey the very thing you want to say. The law is thick with other pain, so why not keep the language plain? Have pity on the legal ear. Just write it tight and write it clear. Thank you very much. I'll be signing autographs in the lobby during the break. Thank you. You'll find that in the actual workbook too if you want. You can sing it at parties. There we go. We have a couple minutes here. That gets us to jargon. And the last of my, for today, rules of the road for less than effective writing. You'll be surprised how unimpressed many people are by legal jargon and technical language. And you'll be, I hope, impressed by the fact that it can often be ineffective and get in the way of effective communication. If, for instance, I brought this one out to Oregon, where I found out once I got there that Nike's based right outside where I was working. Some people would have just said, just do it, right? Lawyers might have come up with a different draft. I hope not. Here's one. Nina, I forgot to check with you. I'm not sure whether Justia or the CLE accrediting agencies require a learned hand quote in every session before they give credit, but I figured why take the chance. So here's a learned hand quote. I think it's a good one. I think it pertains exactly to what we're talking about. The language of the law must not be foreign to the ears of those who are to obey it. And jargon, it seems to me, is not just foreign, but it's also wordier. Okay, so to the extent we can get rid of it, I think we're helpful. It's helpful to us. Let me return to these for a minute. You remember I showed you these early on. They're back in your workbooks again at pages 23 and 24. I'm sorry, 22. Not 23 and 24, 22. We could probably open mics, but I'm not sure how that will work with 170 people. If I say, as lawyers say, is able to, what would you say most other English-speaking humans say? Yeah, you in the back. Yeah, can. Right, exactly. A sufficient number of. Enough, right, good. At this point in time, favorite legal jargon? Now, obviously. How about for the reason that? Because. Good. And again, just quiz yourself, how many of these left side phrases do you find yourself using and how often? And can you see where how most other English-speaking humans might help you? Subsequent to, that's an easy one. After. For the purpose of, I'm getting a little more complicated. You got some more options. Anybody want it? To, with a verb after it. To do thus and such. You might go with in order to, which is still a little bit shorter than for the purpose of. But to might get you there. Let's look at the second half. These are a little more complex, as I said. Nina, should we open up for rewrites or just have me spill the beans here? Your call.
I feel like you can spill the beans, give a few examples. If people chime in, I'll let you know.
Okay, that sounds fine. Notwithstanding the fact that, how about despite in a proper sentence, a particular kind of sentence? Even so, even though, nonetheless, if you've made the fact clear before. In spite of might get you there depending on the sentence you're building. Several options there. And again, think how much longer it takes. Those are those beats again, notwithstanding the fact that. Okay, the next one, during the course of. Sometimes I get some hesitation on this one. How about during? During has a built-in the course of. That's what during means. If you've said during, you've said it all. That's what during means. So just go with during. You've gotten rid of 3 words already. In light of the foregoing considerations. Well, there's a whole range of options there, it seems to me. Depending on how formal you want to be, you can go with therefore. You can go with thus. If you really want to go formal, I assume you can go with hence, though it's not the sort of word I would want to use. But you can even, I've told people in some of my sessions, if you want to go completely wild and crazy, just kick out all the jams and do anything, just completely break any kind of rules you thought you had. How about so? 2 letters. Get you there. Now, you may decide that so is not acceptable for, say, a Supreme Court brief, although I can show you examples where and but and so are included in very official documents from very official places, including courts, high courts. But say you don't. I'm okay with that too. What's comfortable for you? I look at it as a continuum of writing, a continuum of tone. The less formal stuff, the emails, the things to in-house, letters to clients, public facing here, more toward courts and official filings here. Find a spot that's comfortable for you. Where on that continuum do you think you want to be in terms of formality? You may want to go with hence to the Supreme Court. You won't probably want to go to hence with your friends. Likewise with so. Give it a look. Prior to, before. Until such time as. Until is the same. It's the cousin of during. Until will get you there. Until has a built-in such time as. So once again, if you said until, you've said it all. And then finally, in the event that, if, when, should thus and such happen, put it in the subjunctive. There are different possibilities. And again, just take a look at this list in your own time and just mentally see which of the ones you use on the left-hand side and whether there are ways of tightening those up. Okay? And then just for further reading on your own time, again in 23 and 24 in your workbook, another request of ChatGPT. And I asked them for, here, give me some jargony sentences and some less jargony rewrites. You may agree or disagree with some of them. I'm not certain about all of them, but take a look and see what you've got and see whether that gives you some ideas. Again, a way to use ChatGPT and AI as a writing tool without getting into all the problems of hallucination and proprietary information and copyright and all the other concerns that are still very much out there and ought to be paid attention to. Then finally, Something as simple as this. And as she says, I don't always adhere to that advice. And neither will you. But my hope is that gradually you will. And eventually you will more and more. And you'll start defaulting to the tighter, clearer, crisper version of things. Okay? It's just about to wrap up here. Have you ever gotten a compliment like this? I'd like to get to a point where people say, you write like a lawyer, Well, I was thinking of an alternate title for one of my workshops, and I was thinking that might be it. You write like a lawyer, just like a lawyer might not be a compliment. Maybe you want to write a little less like a lawyer. How do you do it? You keep at it. Use your words. When you think you've done it, go back and cut some more. I have a exercise I used to do when I was a columnist, writing 600-word columns, and I've used it in some writing classes as well. I call it this. It looks like a supermarket sale or a department store sale, but it's not. If you've taken a document, in the case of my column, 600 words, 10% is what, 60? Can you take 60 words out of it and turn it into a 540-word document? If you want to get really adventurous, take another swipe. Now you want to take 54 more words out of the 540. Take another 10% out. Can you do that? If you even try to do that, I think you'll start to notice places where there's excess, where there's cuttable stuff. Phrases that don't have to be there, phrases that can be tighter than you've had them. I think you can do that. I hope you will try. A couple more and we'll move to the Q&A. James Baldwin, terrific writer. And again, it's a goal, a sentence that's clean as a bone. You may not get there all the time. There are other considerations. But to be able to reach for that goal, it seems to me, is very much worth it. Or if you think this is not simple enough, how about that one? Eliminate the fluff words. Eliminate the words you don't need. And then to wrap this section up, before we go to further Q&A, as we wrapped up the previous section with 2 mindsets that I hope you'll take away from here. Less can be more. And then finally, am I giving up any words that matter? Okay. And there are the 2 we went through one more time. People feel bombarded. Can you leave anything out? People are busy. Can you get to the point? We are nearly at the end of the trail. You've got my contact information here, and you've got the contact information as well in the workbooks. And I will now bring us back to Q&A and Nina's fine supervision of all of what's gone on here. Thank you so much.
Thank you so much, Rick, for all of your insights on being more concise and creating better legal writing. We can now move on to any other questions. So please feel free to submit those by clicking into the Q&A button in the control panel at the bottom of your screen. Or if you would prefer to verbally ask a question, we certainly welcome that. Please feel free to raise your hand and I will allow you to speak and you can ask Rick your question verbally. All right. Testing that out, Rick. Perfect. Our first question is from an anonymous attendee. They ask, just to get an idea of what they are, and feel free to share your screen again, can you explain the other observations in the 5 observations list? Thank you.
Sure. Let me go back there. Happy to do it. There. Thank you. All righty. People and circumstances differ. Can you adjust? In that, I'm talking a lot about audience. That the audience you have for one type of document may not be the same for another, or even in the same type of document, you might be writing to people with vastly different background in that particular area of law, who are looking for different kinds of information, who are more or less comfortable with legal process. If you say to somebody, as one of the examples I use in my full-day prime prose sessions, if I say to somebody, you've just been issued a TRO, and the example I use mentioned that it was a gas station owner What I tell people is it's unlikely it's one of the rare gas station owners who also has a JD on the side. They've told you as a gas station owner to sort of alert you to the fact that this is not somebody who is going to know what a TRO means as the first item out of the box. Can you adjust to that? So that's number one. The third one, people are confused. Can you offer better help? I talk in my sessions about organizing and how organizing can help lead people through things. And I lay particular stress on the importance of early in the document as a whole, early on each section of the document, even early in each paragraph. I'm not a everybody needs topic sentences all the time kind of person. As I indicated, I'm not an always or never. But I think the top portion of a document, to the extent you have control, obviously jurisdictional claims, procedural statements, and things the court wants, I'll go ahead if they want them ahead. But to the extent you have control, I think the top portion of your document is the most valuable piece of real estate you've got. It sets the tone. It establishes a focus. It lets people know what they should be looking for and what things are most important to focus on. It can even start in the statement of facts. And again, we do some of this in the longer sessions. The statement of facts can even be used to start the persuasion process. You can have the audience, the judge, clerk, whoever, starting to lean your way before they even get to the fuller case. And so I think to the extent you can highlight things up top, the research is they're more persuasive, they're better noticed. The idea of recency, primacy and recency, primacy, the thing that comes first, recency, the thing that you remember as the last thing you've heard, are the two best places, the crunch positions in a sentence and in a document. So that's what number 3 is about. And number 5 is really just a question of tone. We've got into that to some degree when we talk about jargon and trying to avoid it. But the question is, can you use words that are accessible to the person? They're coming to you, if you're a lawyer, for help. Many of them are having a problem. They're in trouble of some sort. They're looking for advice. They're looking for counsel. They're looking for guidance. The language you use, and go back to that slide of the bursts of sunlight and legal knowledge bestowed on the grateful population down. If that's our attitude, and we're conveying that attitude, we're not connecting with the people we're claiming to help. And so can that work? Nina, can I use an example here?
Yeah,
Do we have time for that?
absolutely. Please feel free. We have time.
Sure. One of the, I'll come off this share here. One of the things I mentioned, again, in talking at greater length in some sessions, do you use, say, contractions? Do you start sentences with and, but, or, so? And I mentioned asking a session in Boston, how many of you use contractions? And absolute silence in the room. Absolute silence. Somebody finally raises her hand and she says, "We use contractions, but we're a nonprofit." When the laughter stops, she explains what she meant. And this is what she said. She works a nonprofit in Boston. It's very community outreach oriented. And so she's made it very clear to her people that she wants her shop to feel accessible. And so one way you do that is language. And one way you do language is conversational tone. So she made it a point to use contracted form. So it would be, if you're going to be downtown this weekend, we'll be here all day Saturday, and we'll be here till noon on Sunday. We'd love to see you. Come drop by. We'll be happy to have you here. Okay. I thought it was a perfect choice. So I started sharing that with other sessions later. And a couple of months later, back in DC, I got another woman raising her hand who said that she was the CEO of another nonprofit, and she went exactly the opposite way. And her thinking was this: she belongs to or runs a nonprofit that's big and wants to be bigger in the foundation world. Think thick curtains, think heavy carpet, think, lots of mahogany. She wants her shop to be taken seriously in that world. And so her prohibition was on contracted forms. She wanted a much more serious, formal, I guess you'd call it, language to convey that seriousness, to be a player. Here's the thing. I think she was exactly right too. For her purposes, for her goal, for her audience, getting back to that last 5, can you connect? Her choice was the right choice, just as the woman in Boston's choice was the right choice. And what I often ask people, and sometimes close my sessions with those 2 examples, is say, if something this small, an apostrophe, a curly thing that turns 2 words into a contracted form, if something that small can make that much of a difference, shouldn't we be paying attention to the choices we make all the way through our writing? So that's a longish answer to what are all 5 of those things around.
Thank you, Rick.
Sure.
We had a question that was really, really about that. They were asking about, with situational sifting, like what is the best approach? And so would you say, kind of based on what you just mentioned, that thinking about your goals would be the most
Yeah.
important?
It's your goals. Are you trying? I mean, is the information you're choosing designed to persuade, if that's your goal? Is it chosen to inform? Is it trying to move somebody to action, if that's your goal? You may take different information and prioritize it in a different way. If there's a rally this Saturday and what you're looking to do is move people to action, you want that fairly high in the document. If, and likewise, if what you want to do is just, reassure them about something, that language and that information would be higher in the document. Or left out of the rally might not be important if you're just trying to reassure everything's going to be all right. And you're not calling them to action. So matching your goal and your audience helps you make that situational sifting. Absolutely.
Awesome. Thank you for that additional insight. And we have time for one more question. So this is really just about with the intention of writing. Often lawyers are not trying to be overly inclusive. They're just trying to make sure things have structural clarity. So how would you say it would be a good approach to recognizing when there's too much wordiness and we need to cut it down without losing that structural clarity?
Have you started, for instance, with an outline? Some people do, some people don't. If the feedback you're getting is your stuff is disorganized, or it's either redundant in sections or it's missing a section, there's no clear transition between this and that, you can probably spot that even at the outline stage and see whether there's something missing or whether the thing you've got in the equivalent of basket 2 is something you're saying again in basket 5. Maybe you can combine those 2. Maybe you don't need those both. If it's important enough, maybe you want to move it up from 5 into 2. So that's one way of doing it. Another is, are you using any kinds of headings, subheads, linking words to make clear what the flow of the discussion is? You don't need necessarily large phrases to get you there, but even a linking, as a consequence. So therefore, meanwhile, in another part of town, that sort of thing, to let people move from section to section. Subheads will also do that. Bullet points will also do that. So that's what I would suggest there as a couple of alternative approaches.
Awesome. Well, thank you so much, Rick, for all of your insights and answering our audience questions. And thank you all so much for asking your questions.
Yes, thank you. I wanted to have a conversation. As I said, if it was only my voice, I would feel I had let you down and let myself down. So thank you, and thank Nina for letting those in and filtering them in the right places and all that. Thank you all. I enjoyed it. I hope our paths meet again. I've got contact information and various readings and various writing exercises and self-assessment things in the appendix of the workbook. I hope you'll take a look at those and spread the word. All the best, and here's to CRISPR writing. Thanks.
Thank you so much, Rick. We want to thank you all so much for joining us today for another Justia webinar. As I mentioned at the start, I want to remind you about the services available through our website platform, Justia Elevate, a WordPress-based solution that's built specifically for lawyers and law firms. It offers many features, but most of which is our Justia AI Writer, most pertinent to today's topic. It's our exclusive tool for creating high-quality legal content for your website to help you easily generate content across various practice areas and improve your website's SEO. And of course, you can edit that generated content with some of those excellent tips we received from Rick today. To learn more, you can visit elevate.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks again. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.